Birthplace does not automatically define inheritance rights. In cross-border families, one recurring question arises. Do children born abroad have inheritance rights in Vietnam? The answer depends not on birthplace alone, but on legal status and applicable inheritance law. The core principle: children as first-line heirs. Under Vietnamese inheritance law, children are first-line statutory heirs. This includes biological children recognized under law. Birth outside Vietnam does not eliminate that status. Legal recognition of parentage is decisive. Inheritance rights depend on legally recognized parent-child relationships. If paternity or maternity is formally recorded, the child qualifies as a statutory heir. Documentation is critical. Foreign birth certificates and legalization. Children born abroad typically hold foreign birth certificates. To assert inheritance rights in Vietnam, those documents must be legalized where applicable and translated into Vietnamese. Procedural compliance determines recognition. Nationality does not automatically exclude rights. A child holding foreign nationality may still inherit assets located in Vietnam. Vietnamese inheritance law focuses on family relationship, not passport status. However, asset-specific regulations may affect ownership rights. Real estate in Vietnam. For immovable property located in Vietnam, Vietnamese inheritance law governs succession. Children born abroad may inherit land use rights and housing interests. However, if the heir does not meet ownership conditions under Vietnamese land and housing regulations, the heir may be required to transfer or dispose of the property within statutory time limits. Economic entitlement does not always equal indefinite ownership. Forced heirship protections. Under the Vietnamese Civil Code, minor children and adult children without working capacity are classified as compulsory heirs. If a child born abroad falls within these statutory categories, they are entitled to a protected minimum share of the estate. This protection applies regardless of the wording of a will. When a will attempts exclusion. If a will excludes a child born abroad, courts may examine whether the child qualifies for compulsory share protection. If so, statutory minimum entitlements may apply. Testamentary freedom is structured. Children from prior relationships. Inheritance disputes frequently arise where the deceased had children abroad from a previous relationship. The surviving spouse and domestic children may face competing claims. Clear documentation reduces litigation risk. Unrecognized or unregistered children. If a child born abroad is not formally recognized under Vietnamese law, inheritance claims may require judicial determination of parentage. Evidence standards are strict. Timing affects enforceability. Adopted children born abroad. Adopted children may also qualify as heirs if adoption is legally recognized. Foreign adoption decisions may require recognition in Vietnam. Procedural recognition is essential before inheritance distribution. Dual nationality complexities. Children with dual nationality may face parallel legal processes in different jurisdictions. Vietnamese law governs domestic assets. Foreign law may govern overseas assets. Coordination is required. Tax and reporting obligations. Inheritance tax treatment may vary depending on relationship classification. Close relatives often benefit from exemptions under Vietnamese tax rules. Proper classification ensures compliance. Dispute scenarios involving overseas children. Challenges may involve claims of unequal distribution, testamentary capacity, or procedural defects. Cross-border communication gaps often escalate tension. Structured estate planning reduces ambiguity. Proof of dependency and compulsory status. For minor children, compulsory heir status applies automatically under the Civil Code. For adult children, protection depends on demonstrating lack of working capacity, not merely financial dependence. Courts assess statutory criteria strictly. Assumption of vulnerability is insufficient. Property ownership restrictions for foreign heirs. If a child born abroad does not satisfy conditions to register ownership under Vietnamese housing law, the heir may inherit the economic value but must transfer the property in accordance with statutory regulations. Retention depends on legal eligibility, not inheritance status alone. Coordination with foreign probate. If probate proceedings occur abroad simultaneously, Vietnamese inheritance rights must still be addressed for domestic assets. Foreign court orders require recognition procedures before local enforcement. Estate planning for multinational families. Parents with children born abroad should review estate plans proactively. Ensure formal recognition of parentage. Align wills with Vietnamese compulsory heir rules. Coordinate across jurisdictions. Practical takeaway for overseas Vietnamese and expats. Children born abroad are not excluded from inheritance rights in Vietnam simply due to birthplace or nationality. Legal recognition of relationship and compliance with procedural requirements are decisive. Documentation determines enforceability. Final message: rights follow legal status, not geography. Inheritance rights of children born abroad in Vietnamese estates depend on legally recognized family relationships and applicable domestic law. Birthplace alone does not negate entitlement. In cross-border estates, clarity of status and structured planning prevent conflict. Without formal alignment, courts will define the outcome. If you have children born abroad and hold assets in Vietnam, do not assume inheritance rights will be administratively simple. Parentage recognition, document authentication, compulsory heir rules, and property eligibility all shape the final outcome. Before succession issues arise, review your estate structure under Vietnamese law to ensure that cross-border documentation and family status are legally aligned. For structured legal guidance on multinational inheritance matters, contact LTS Law at lts.com.vn. In cross-border estates, rights follow legal recognition, not geography.